Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional legal, financial, or psychological advice. Every individual case is unique, and the laws regarding family matters vary significantly by state and jurisdiction. The historical trends and case studies discussed here are intended to provide context and perspective, not a roadmap for specific legal actions. You should always consult with a qualified attorney, certified public accountant, or licensed therapist to address your specific circumstances. Viewers are strongly encouraged to conduct their own due diligence and research before making any decisions that could impact their legal standing or financial future. In 1969, Ronald Reagan, then governor of California, signed the Family Law Act into existence. It was a move that effectively created no-fault divorce in the United States, and later in his life, Reagan would describe it as one of the greatest mistakes of his political career. For decades, the American male has been navigating a system that was built on the ruins of the 19th century household, a system that transitioned almost overnight from viewing children as property of the father to viewing them as the emotional ward of the mother. Today, roughly 70% of divorces in the United States are initiated by women, a number that jumps to 90% when the women are college-educated. This is not just a statistic, it is a cultural earthquake. If you are a man in America today looking for help, guidance, or even just a sense of where you stand, you are walking through a landscape shaped by 300 years of shifting legal definitions, social stigmas, and economic revolutions. We are going to peel back the layers of this history to understand exactly how the system evolved, why the modern courtroom feels like an uphill battle for so many fathers, and how understanding these historical trends can help you navigate your own journey with clarity and composure. This masterclass is designed to solve one primary problem: the lack of historical and systemic perspective that often leaves men feeling blindsided by the legal process. By the time we finish this 10-part series, you will understand the potential outcomes of the modern legal system through the lens of history. We will move past the emotional noise and look at the cold, hard evolution of custody law, alimony, and the cultural perception of the divorced man. This is not about winning or losing in a traditional sense. It is about providing you with the intellectual and historical tools to understand the landscape so you can protect your future and the future of your children. We are going to look at how we got here, from the colonial days when divorce was a legislative act of God to the modern era, where a smartphone can be the primary witness in a custody battle. To understand the help available to men today, we must first look at the era of the agrarian patriarch. In the late 1700s and early 1800s, the concept of a men's help center, or a divorce attorney for men, was non-existent, because the legal system was almost entirely tilted in favor of the male head of household. In this period, children were viewed as economic assets. They were a labor force on the family farm, and legally, they were considered the property of the father. If a marriage dissolved, which was incredibly rare and often required an act of the state legislature, the father almost always retained custody because he was the one with the land, the income, and the legal standing. However, the Industrial Revolution changed everything. As men moved from the farms to the factories, they were removed from the home for 12 to 14 hours a day. This created the separate spheres doctrine. The home became the feminine domain of nurturing and morality, while the outside world was the masculine domain of commerce and conflict. This shift led to the creation of the tender years doctrine in the mid-19th century. This was the first major historical trend that shifted the balance of power in domestic help. The tender years doctrine suggested that during a child's tender years, usually defined as under the age of 7, the mother was the uniquely qualified caregiver. Consider the case study of the Talfords Act of 1839 in England, which heavily influenced American law. It allowed mothers to petition the court for custody of children under 7. While it seemed like a small shift, it was the first domino to fall in a century-long move toward maternal preference. For the American man, this meant that for the first time, his biological and economic connection to his children was no longer a guarantee of a continued relationship post-separation. He was being redefined solely as a provider, rather than a parent. As we moved into the 20th century, the fault-based era became the primary hurdle. To get a divorce, someone had to be the villain. You couldn't just walk away because you were unhappy. You had to prove adultery, extreme cruelty, or abandonment. For many men, the only way to get help, or a way out, was to engage in what historians call collusive divorce. There are recorded instances in the 1930s and 40s where men would hire professional correspondents, women whose only job was to be photographed in a hotel room with the husband, so the wife could sue for divorce on the grounds of adultery. The man would intentionally ruin his own reputation to gain his freedom. This created a culture where the man was almost always the legal wrongdoer, a stigma that many argue still lingers in the subconscious of the family court system today. Then came the Reno phenomenon. In the mid-20th century, Nevada became the divorce capital because it had a short 6-week residency requirement and more lenient grounds for divorce. We saw a historical trend of migratory divorce, where men who had the financial means would travel to Reno, live in a dude ranch for 6 weeks, and secure a divorce that was nearly impossible to get in their home states like New York or South Carolina. This was the first iteration of men's divorce help, a tactical exploitation of state-line jurisdictions. It was expensive, it was risky, and it highlighted the massive disparity between men who had resources and those who did not. Understanding this history is vital because the modern help systems, the law firms that specialize in representing fathers, the support groups for divorced men, and the legislative lobbies for 50-50 shared parenting, are all direct responses to these historical shifts. We are living in the aftershocks of the no-fault revolution of the 1970s. When Reagan signed that bill, the intention was to reduce the bitterness and perjury of the fault era. But an unintended consequence was the removal of leverage. In a fault-based system, a man who was innocent of wrongdoing had significant leverage in financial negotiations. In a no-fault system, that leverage vanished, often leading to potential outcomes where a man could lose his home, his savings, and his access to his children without having done anything legally wrong. Throughout this series, we are going to look at the data surrounding these outcomes. We will examine how the best interests of the child standard, which replaced the tender years doctrine, is interpreted in different states. We will look at step-by-step details on how the financial landscape of divorce changed from alimony as a lifetime pension to rehabilitative maintenance. By looking back at the 1950s, an era often romanticized as the peak of the nuclear family, we see the roots of the modern struggle. The 1950s man was under immense pressure to be the sole provider, a role that, while powerful, made him highly vulnerable in the event of a marital breakdown. If he was the sole earner, he was also the sole source of alimony and child support, often leaving him with very little to rebuild his own life. We will explore how the transition from an industrial economy to a service and information economy has further complicated these roles, making the old legal frameworks increasingly obsolete. This deep dive is about more than just dates and laws. It is about the psychology of the American man in the legal system. It is about understanding that the help you seek today is part of a 300-year evolution of what it means to be a father, a husband, and an individual in the eyes of the state. We are going to provide you with the historical context so that when you sit down with a lawyer or a mediator, you aren't just reacting to the present moment, you are navigating a system with the wisdom of the past. This is the foundation. This is the history of how the American man's place in the family was redefined. And in the next part, we will begin looking at the specific legal shifts of the 20th century that created the modern courtroom environment. To understand the specific legal shifts of the 20th century that created the modern courtroom environment, we have to look at the massive transition from a system based on moral failure to a system based on administrative logistics. Imagine you are a man named Robert living in 1955. If you wanted to seek divorce help, your options were incredibly narrow and often required you to participate in a theatrical performance of guilt. In the 1950s, the legal system was designed to keep families together at almost any cost. To get a divorce, Robert would have had to prove that his spouse had committed a specific legal wrong, such as adultery, physical cruelty, or desertion. If he could not prove one of these specific faults, the court would simply deny the divorce, leaving him in a legal limbo where he was married but separated, unable to move on with his life or protect his assets. The help available to men like Robert usually came in the form of private investigators who specialized in catching spouses in compromising positions. This was the era of the keyhole peekers. Because the law required proof of fault, the courtroom became a battlefield of accusations. However, a significant historical trend during this time was the concept of the migratory divorce. If Robert had the financial means, he could travel to a state like Nevada, which had established a thriving industry around lenient divorce laws. By 1955, Nevada allowed for a divorce after only 6 weeks of residency, and the grounds for divorce included mental cruelty, which was much easier to claim than adultery. This created a two-tiered system of help: those who could afford to travel for a quick exit, and those who were stuck in the adversarial systems of their home states. By the time we reached the late 1960s, the pressure on this fault-based system reached a breaking point. Judges and lawyers were becoming weary of the blatant perjury and collusion that characterized divorce proceedings. This led to the 1970 California no-fault revolution, when Governor Ronald Reagan signed the Family Law Act of 1969, which went into effect on January 1, 1970. It signaled the most significant shift in the history of American domestic relations. For the first time, a man didn't have to prove his wife was a villain to end a marriage. He only had to state that there were irreconcilable differences. While this was framed as a liberation for both genders, the potential outcomes for men were complex. In the old system, an innocent husband could use his lack of fault as leverage to negotiate a better financial settlement, or to maintain his relationship with his children. Once no fault became the standard, that leverage disappeared overnight. The courtroom shifted from a place of moral judgment to a place of asset distribution. This is where we see the birth of modern divorce help for men as a specialized field. Attorneys began to realize that without the shield of fault, men needed a new kind of defense centered on economic protection and parental rights. One of the most pivotal moments in this era was the 1979 Supreme Court case of versus Orr. Before this case, many states had laws that only required husbands to pay alimony, never wives. William Orr challenged this in Alabama, arguing that it violated the Equal Protection Clause of the 14th Amendment. The Supreme Court agreed, ruling that alimony must be gender-neutral. This case study is essential because it represents the first time the highest court in the land acknowledged that men could also be in a position of financial vulnerability following a divorce. It opened the door for a more balanced view of financial support, even if the cultural application of that balance took decades to catch up. As we moved into the 1980s, the focus shifted from the spouses to the children. The tender years doctrine, which we discussed in the previous part, was being phased out in favor of the best interests of the child standard. This sounds neutral and fair, but in practice it created a new kind of uncertainty for fathers. Imagine a man named David in 1985. He is a hands-on father, but the law still defaults to the idea that the mother is the primary caregiver. To get help, David had to hire child psychologists and expert witnesses to prove that his involvement was essential to his child's well-being. The 1980s saw the rise of the guardian ad litem, an independent representative appointed by the court to investigate the family and make recommendations. For many men, this added another layer of bureaucracy and cost to the process. This period also saw the federal government step in to regulate child support. The Child Support Enforcement Act of 1984 and the Family Support Act of 1988 mandated that states create specific mathematical formulas for child support. This moved the process further away from judicial discretion and toward a cold, calculated administrative function. For the American man, this meant that his financial future was now being determined by a spreadsheet. The help he needed was no longer just legal, it was increasingly financial and mathematical. Men started seeking out accountants and financial planners who understood how these state-mandated formulas functioned. In the 1990s and early 2000s, a new historical trend emerged: the push for joint custody. Before this time, the winner-take-all model was the standard, where one parent got primary custody and the other got every other weekend. Men began to organize, forming the first major fathers' rights groups. These organizations provided a new kind of help, offering peer support and lobbying for legislative changes that presumed joint custody was in the best interest of the child. We began to see states like Florida and Arizona move toward a 50-50 timesharing model as the default starting point. This was a radical departure from the 19th century view of children as property, or the 20th century view of children as the mother's domain. Step by step, the courtroom was being redesigned. By the year 2026, the process has become highly digitized and standardized. A man entering the system today isn't just dealing with a judge. He is dealing with a suite of algorithms, mandatory mediation sessions, and parent education classes. The help available has evolved from the private investigator in the shadows to the high-tech forensic accountant, who can track digital assets and cryptocurrency. Consider a case study from 2026. A man named James is going through a divorce. His help doesn't just come from a lawyer. It comes from a data-driven strategy. He uses apps to document every minute of his parenting time, every expense he pays, and every communication with his spouse. The legal system has become a game of documentation. In the 1950s, the man with the best story won. In the 2026 landscape, the man with the best data has the highest probability of a stable outcome. This evolution from moral fault to administrative data is the secret history of the American divorce. It explains why the modern courtroom feels so cold and transactional to many men. It is a system that has been stripped of its human element in an attempt to be fair. Yet in that stripping, it has created a new set of challenges that require a specific modern kind of help. As we look at the potential outcomes of this long historical journey, we see that the American man has gone from having all the power, to being the designated villain, to now being a data point in a vast administrative machine. But understanding this transition is only half the battle. To truly navigate the system, you have to understand the specific economic traps that were set during these transitions, traps that many men are still stepping into today. In the next part, we are going to look at the secret history of the alimony trap. We will explore how a law designed to protect 19th century homemakers became a multi-billion-dollar industry in the 21st century, and we will break down the specific legislative changes that are finally starting to turn the tide. If you think alimony is just about a monthly check, you are missing the biggest shift in the history of wealth transfer in America. To understand the specific legal shifts of the 20th century that created the modern courtroom environment, we have to look at the massive transition from a system based on moral failure to a system based on administrative logistics. Imagine you are a man named Robert living in 1955. If you wanted to seek divorce help, your options were incredibly narrow, and often required you to participate in a theatrical performance of guilt. In the 1950s, the legal system was designed to keep families together at almost any cost. To get a divorce, Robert would have had to prove that his spouse had committed a specific legal wrong, such as adultery, physical cruelty, or desertion. If he could not prove one of these specific faults, the court would simply deny the divorce, leaving him in a legal limbo where he was married but separated, unable to move on with his life or protect his assets. The help available to men like Robert usually came in the form of private investigators who specialized in catching spouses in compromising positions. This was the era of the keyhole peekers. Because the law required proof of fault, the courtroom became a battlefield of accusations. However, a significant historical trend during this time was the concept of the migratory divorce. If Robert had the financial means, he could travel to a state like Nevada, which had established a thriving industry around lenient divorce laws. By 1955, Nevada allowed for a divorce after only 6 weeks of residency, and the grounds for divorce included mental cruelty, which was much easier to claim than adultery. This created a two-tiered system of help: those who could afford to travel for a quick exit, and those who were stuck in the adversarial systems of their home states. By the time we reached the late 1960s, the pressure on this fault-based system reached a breaking point. Judges and lawyers were becoming weary of the blatant perjury and collusion that characterized divorce proceedings. This led to the 1970 California no-fault revolution, when Governor Ronald Reagan signed the Family Law Act of 1969, which went into effect on January 1, 1970. It signaled the most significant shift in the history of American domestic relations. For the first time, a man didn't have to prove his wife was a villain to end a marriage. He only had to state that there were irreconcilable differences. While this was framed as a liberation for both genders, the potential outcomes for men were complex. In the old system, an innocent husband could use his lack of fault as leverage to negotiate a better financial settlement, or to maintain his relationship with his children. Once no fault became the standard, that leverage disappeared overnight. The courtroom shifted from a place of moral judgment to a place of asset distribution. This is where we see the birth of modern divorce help for men as a specialized field. Attorneys began to realize that without the shield of fault, men needed a new kind of defense centered on economic protection and parental rights. One of the most pivotal moments in this era was the 1979 Supreme Court case of Orr versus Orr. Before this case, many states had laws that only required husbands to pay alimony, never wives. William Orr challenged this in Alabama, arguing that it violated the Equal Protection Clause of the 14th Amendment. The Supreme Court agreed, ruling that alimony must be gender-neutral. This case study is essential because it represents the first time the highest court in the land acknowledged that men could also be in a position of financial vulnerability following a divorce. It opened the door for a more balanced view of financial support, even if the cultural application of that balance took decades to catch up. As we moved into the 1980s, the focus shifted from the spouses to the children. The tender years doctrine, which we discussed in the previous part, was being phased out in favor of the best interests of the child standard. This sounds neutral and fair, but in practice it created a new kind of uncertainty for fathers. Imagine a man named David in 1985. He is a hands-on father, but the law still defaults to the idea that the mother is the primary caregiver. To get help, David had to hire child psychologists and expert witnesses to prove that his involvement was essential to his child's well-being. The 1980s saw the rise of the guardian ad litem, an independent representative appointed by the court to investigate the family and make recommendations. For many men, this added another layer of bureaucracy and cost to the process. This period also saw the federal government step in to regulate child support. The Child Support Enforcement Act of 1984 and the Family Support Act of 1988 mandated that states create specific mathematical formulas for child support. This moved the process further away from judicial discretion and toward a cold, calculated administrative function. For the American man, this meant that his financial future was now being determined by a spreadsheet. The help he needed was no longer just legal, it was increasingly financial and mathematical. Men started seeking out accountants and financial planners who understood how these state-mandated formulas functioned. In the 1990s and early 2000s, a new historical trend emerged: the push for joint custody. Before this time, the winner-take-all model was the standard, where one parent got primary custody and the other got every other weekend. Men began to organize, forming the first major fathers' rights groups. These organizations provided a new kind of help, offering peer support and lobbying for legislative changes that presumed joint custody was in the best interest of the child. We began to see states like Florida and Arizona move toward a 50-50 timesharing model as the default starting point. This was a radical departure from the 19th century view of children as property or the 20th century view of children as the mother's domain. Step by step, the courtroom was being redesigned. By the year 2026, the process has become highly digitized and standardized. A man entering the system today isn't just dealing with a judge. He is dealing with a suite of algorithms, mandatory mediation sessions, and parent education classes. The help available has evolved from the private investigator in the shadows to the high-tech forensic accountant, who can track digital assets and cryptocurrency. Consider a case study from 2026. A man named James is going through a divorce. His help doesn't just come from a lawyer. It comes from a data-driven strategy. He uses apps to document every minute of his parenting time, every expense he pays, and every communication with his spouse. The legal system has become a game of documentation. In the 1950s, the man with the best story won. In the 2026 landscape, the man with the best data has the highest probability of a stable outcome. This evolution from moral fault to administrative data is the secret history of the American divorce. It explains why the modern courtroom feels so cold and transactional to many men. It is a system that has been stripped of its human element in an attempt to be fair. Yet in that stripping, it has created a new set of challenges that require a specific modern kind of help. As we look at the potential outcomes of this long historical journey, we see that the American man has gone from having all the power, to being the designated villain, to now being a data point in a vast administrative machine. But understanding this transition is only half the battle. To truly navigate the system, you have to understand the specific economic traps that were set during these transitions, traps that many men are still stepping into today. In the next part, we are going to look at the secret history of the alimony trap. We will explore how a law designed to protect 19th century homemakers became a multi-billion-dollar industry in the 21st century, and we will break down the specific legislative changes that are finally starting to turn the tide. If you think alimony is just about a monthly check, you are missing the biggest shift in the history of wealth transfer in America. To understand the alimony trap, we have to travel back to the era of coverture, a legal doctrine where a woman's legal rights were subsumed by those of her husband upon marriage. In the 18th and 19th centuries, alimony was not a tool for wealth transfer in the way we think of it today. It was a matter of survival. Because women were often legally barred from owning property or earning their own wages, alimony was the state's way of ensuring that a divorced woman did not become a public charge. The man was legally obligated to provide because the state did not want to foot the bill for her subsistence. This historical trend established the foundation of alimony as a lifelong obligation. However, as the 20th century progressed and women entered the workforce in record numbers, the legal justification for permanent alimony began to crumble. Yet the statutes remained on the books in many states for decades. Imagine a man named Michael in the year 2026. Michael has been married for 22 years and earns a high six-figure salary. In the mid-20th century, a man in Michael's position would have likely faced a permanent alimony award, meaning he would be writing a check every month until either he or his ex-spouse passed away or she remarried. This was the traditional permanent periodic alimony model. But the help available to Michael today looks very different because of the massive legislative shifts that occurred between 2010 and 2025. Historical trends show an aggressive move toward durational alimony. This is a system where the length of the payments is tied strictly to the length of the marriage. In many modern jurisdictions, if Michael was married for 22 years, the potential outcomes for the duration of his alimony might be capped at 50 to 75% of the length of the marriage. This shift from permanent to durational is one of the most significant victories for men seeking financial clarity in the modern era. One of the most critical turning points in this history was the Tax Cuts and Jobs Act of 2017, which completely overhauled the math of divorce in America. Before January 1, 2019, alimony was tax-deductible for the payer and taxable income for the recipient. This created a divorce subsidy from the federal government. If a man in a high-tax bracket paid $100,000 in alimony, his actual out-of-pocket cost might only be $65,000 because of the tax deduction. This allowed for more flexibility in negotiations. However, for any divorce finalized after December 31, 2018, that deduction vanished. Now, Michael in 2026 has to pay alimony with post-tax dollars, and the recipient receives it tax-free. This increased the effective cost of alimony for men by approximately 20 to 30%. This historical shift changed the nature of divorce help overnight. Financial experts and forensic accountants became more vital than ever, as they had to find new ways to structure settlements, such as front-loading property distribution instead of ongoing maintenance, to mitigate this massive tax hit. Let's look at a case study from the alimony reform movement, specifically focusing on states like Massachusetts and Florida. In Massachusetts, the Alimony Reform Act of 2011 was a landmark piece of legislation that was largely driven by men who felt the previous system was archaic. Before this act, judges had almost unlimited discretion, leading to unpredictable and often life-shattering awards. The reform introduced clear categories: rehabilitative alimony, intended to help a spouse become self-sufficient; reimbursement alimony, for those who supported a spouse through advanced education; and durational alimony, which established clear end dates. For a man seeking help in Massachusetts after 2011, the guesswork was largely removed. He could look at a chart and have a high probability of predicting his financial exposure. In Florida, the battle was even more intense. It took multiple legislative attempts and several gubernatorial vetoes before permanent alimony was finally abolished in 2023. This change was a massive shift for the silver splitters, men over the age of 50 who were entering divorce later in life. Before this change, a man retiring at 65 might still be obligated to pay permanent alimony based on his peak earning years, even if his income dropped significantly in retirement. The new laws in 2026 provide a much more robust framework for the modification of alimony upon retirement. This is where the modern help comes in. Men now utilize retirement protection clauses that were virtually unheard of 40 years ago. Imagine if you were a man in 1980 trying to modify your alimony because you lost your job. You would have had to prove a substantial, involuntary, and permanent change in circumstances. The burden of proof was incredibly high, and the legal fees to fight that battle often outweighed the potential savings. Fast forward to 2026, and the legal help for men includes automated software that tracks income fluctuations and market trends to trigger automatic mediation or adjustment clauses. We have moved from a system of judicial whim to a system of contractual precision. However, even with these reforms, the alimony trap still exists in the form of the standard of living argument. Many courts still use the phrase to maintain the standard of living established during the marriage. This is where the deep dive into financial data becomes essential. In a 2026 courtroom, a man's defense often centers on a step-by-step breakdown of shared expenses versus individual needs. The help he receives from a specialized divorce financial analyst involves creating a lifestyle analysis that proves the marital standard of living was inflated by debt or one-time windfalls, rather than sustainable income. By providing this data, the man can potentially lower the baseline for alimony calculations. We also have to consider the cultural shift in how alimony is perceived. In the 1970s, receiving alimony was often seen as a badge of a failed marriage where the woman was the victim. Today, with the rise of dual-income households, we are seeing a historical trend of more men being eligible for alimony, though the numbers remain low. Case studies from 2025 show an uptick in stay-at-home fathers seeking maintenance. This gender neutrality, while legally mandated since 1979, is finally becoming a practical reality in the negotiations. It has forced the system to become more objective. When a man is the one asking for support, the court is often more rigorous in demanding proof of need, which ironically has led to a more rigorous standard being applied to everyone. The secret history of wealth transfer and divorce is not just about the checks written. It is about the assets retained. The help men need today involves understanding the difference between marital property and non-marital property. In many states, any appreciation on a premarital business or real estate holding can be considered marital property if marital effort was involved. Step by step, men are now being coached to wall off their assets using postnuptial agreements and sophisticated trust structures. This is the new frontier of divorce help, preventative legal architecture that anticipates the historical trends of the courtroom. The evolution of alimony from a survival mechanism to a durational contract has changed the life trajectory of millions of American men. It has moved from a permanent shadow over a man's future to a manageable, if still painful, financial obligation. But as the financial battlefield became more regulated, the conflict shifted elsewhere. The legal system began to see a surge in a different kind of warfare, one that didn't involve bank accounts, but rather the very hearts and minds of the next generation. If you think the fight over money is intense, it pales in comparison to the era we are about to enter. We are going to look at the rise of the psychological battlefield, the history of how parental alienation was identified, and the dark evolution of how children became the ultimate leverage in the modern American divorce. The shift from fighting over the wallet to fighting over the soul of the child is a move that changed the legal landscape forever, and it's a history that every man needs to understand before he ever steps foot in a courtroom. The transition from the financial battlefield to the psychological one began in earnest during the late 1970s and early 1980s, as the legal system realized that while money could be divided by a calculator, the human heart could not. When the tender years doctrine was finally discarded across most of the United States, it was replaced by a standard that sounds inherently fair, but has proven to be one of the most complex legal hurdles for men in history: the best interests of the child. This standard moved the focus away from parental rights and toward a subjective analysis of a child's well-being. For the American man, this meant the help he needed was no longer just found in a law book. It was found in the offices of forensic psychologists and custody evaluators. Imagine a father named Mark in the year 2026. Mark is a dedicated parent who has spent the last decade balance testing his career and his time at home. However, as his marriage dissolves, he finds himself ensnared in a psychological narrative that he was never truly the primary caregiver. This is not a new phenomenon. It is the culmination of a historical trend that gained momentum in the 1980s. During that decade, a child psychiatrist named Richard Gardner coined the term parental alienation syndrome, or PAS. Gardner observed that in high-conflict divorces, one parent, statistically more often the mother at that time due to her role as the primary gatekeeper of the home, would systematically disparage the other parent to the point where the child would reject them entirely. Gardner's work was revolutionary because it gave men a vocabulary to describe what they were experiencing. For the first time, a man could walk into a courtroom and explain that his child's sudden hostility was not a natural reaction, but a programmed one. However, the history of PAS is a contentious one. By the late 1990s and early 2000s, there was a significant pushback from various advocacy groups who argued that PAS was being used by abusive fathers to silence legitimate concerns from mothers and children. This created a decade of legal gridlock where the very help men sought, recognition of alienation, was often dismissed as junk science. In 2026, the legal landscape has shifted again. Instead of focusing on a syndrome, the courts now look at the historical trend of restrictive gatekeeping. This is a step-by-step analysis of how one parent facilitates or hinders the child's relationship with the other. To understand how Mark navigates this in 2026, we have to look at the rise of the custody evaluator. In the 1990s, if a father wanted to prove his fitness, he might just bring in character witnesses. Today, a man in Mark's position must undergo a battery of psychological tests, such as the MMPI-3, the latest version of the Minnesota Multiphasic Personality Inventory. These tests are designed to detect everything from personality disorders to the tendency to underreport negative traits. For a man seeking help, the strategy has evolved into a meticulous preparation for these evaluations. He is coached by specialists not to lie, but to understand how his answers will be interpreted through the lens of a system that is often looking for any reason to maintain the status quo of the primary maternal bond. One of the most significant case studies in this psychological evolution is the 1990s era of the Satanic Panic and its influence on domestic law. During this time, there was a surge in high-profile cases where false allegations of extreme ritual abuse were leveled during custody battles. While these cases were often debunked, they left a lasting scar on the family court system. They proved that a single well-placed allegation could freeze a father's access to his children for years, while an investigation took place. This historical trend led to the development of the silver bullet strategy, a term used in the legal community to describe how some litigants use the system's protective instincts to gain an unfair advantage in custody. For men in 2026, the help against these potential outcomes is found in digital forensic documentation. Consider the role of co-parenting apps like Our Family Wizard or Talking Parents. In the early 2000s, these were optional tools for high-conflict couples. By 2026, they are often court-mandated from the very first filing. These apps create a permanent, unalterable historical record of every interaction. If Mark's ex-spouse tells him he cannot see the children on his scheduled Tuesday because they are sick, but then posts photos of them at a birthday party, Mark has an immediate time-stamped piece of evidence. This is the new help, the transition from he said she said to data-proven fact. We also have to look at the history of the guardian ad litem or GAL. This is a person appointed by the court to represent the child. Historically, the GL was often an attorney with little psychological training. In the early 2000s, fathers began to realize that the GL held the power of a judge without the same oversight. Help for men in this era shifted toward the hiring of rebuttal experts. If a GAL made a recommendation that favored the mother based on outdated stereotypes, the father would hire his own expert to review the GAL's report for bias. This created a shadow industry of psychological auditing that remains a staple of the 2026 masterclass in divorce strategy. The psychological battlefield also includes the concept of the enmeshed child. This is a historical trend where, during the long delays of the court system, a child becomes so psychologically intertwined with one parent that they lose their own sense of identity. By the time a judge finally hears the case, which in some jurisdictions can take 18 to 24 months, the status quo has been established. The judge, hesitant to disrupt the child's current environment, often rules in favor of the parent who successfully delayed the process. This is why the help men seek today is focused on temporary orders. The first 30 days of a divorce in 2026 are more critical than the trial itself. A man who does not secure a 50-50 temporary time-sharing order at the outset is fighting a historical uphill battle against the presumption of the status quo. Furthermore, we must examine the impact of social media on the psychological landscape. In 2026, every post, every like, and every comment is a potential exhibit. Men are now coached to undergo a digital scrub, not to hide who they are, but to prevent the historical rewriting of their character. A photo of a man holding a beer at a barbecue in 2018 can be presented in a 2026 courtroom as evidence of a substance abuse problem, if not placed in its proper context. The help available now includes digital reputation managers who specialize in family law, ensuring that the man's online history matches his courtroom persona as a responsible, engaged father. As we move forward, it becomes clear that the American man has had to become a student of psychology as much as a student of law. He has had to learn to manage his own emotional responses in the face of what is often perceived as systemic provocation. This leads us to a critical realization. The psychological battlefield is not just about the children. It is about the man's own survival and his ability to remain a presence in his children's lives despite the pressure to withdraw. The historical shifts we have discussed, from the rise of PS to the data-driven era of 2026, all point toward a single conclusion. The system has moved from assuming the father is the head of the house to requiring him to prove he is even a member of the family. But there is a massive cultural force that has been brewing in the background of these courtroom dramas. It is a force that moved from the fringes of the internet to the center of the American conversation. In the next part, we are going to explore the rise of the digital resistance. We will look at how the 2010s gave birth to a new kind of support system for men, one that didn't just offer legal help, but a total reevaluation of the marriage contract itself. We will dive into the history of the manosphere, the red pill movement, and how these cultural shifts have fundamentally changed how the 2026 man approaches the very idea of family and the state. If you think the courtroom is the only place where the battle is being fought, you are only seeing half of the picture. The rise of the digital resistance was not an organized movement with a central headquarters or a formal manifesto. Rather, it was a decentralized explosion of information that began in the dark corners of early internet message boards and migrated into the mainstream consciousness by 2026. To understand the help available to men today, we must look at the historical trend of the intellectual underground. In the early 2010s, men who felt disenfranchised by the family court system began to congregate on platforms like Reddit and various independent blogs. They were looking for something the traditional legal system wouldn't give them: a diagnostic framework for why their lives were collapsing. This era gave birth to the concept of the red pill, a metaphor borrowed from the 1999 film The Matrix, representing a painful awakening to what these men perceived as the underlying socio-biological realities of modern relationships. This shift changed the nature of divorce help from reactive to proactive. Instead of asking how to win a custody battle, men began to ask why they were in a position to lose one in the first place. Imagine a man named Ethan in the year 2026. Ethan is a 34-year-old systems architect who has watched the potential outcomes of his peers' marriages with a clinical eye. Unlike his father, who entered marriage in the 1990s with a romanticized, traditional view of the contract, Ethan has access to a decade's worth of digital archives that treat marriage as a high-stakes legal and economic merger. For Ethan, help doesn't start at the courthouse, it starts with the vetting process. This is the first major cultural shift: the move toward comprehensive risk assessment. Ethan utilizes historical trends and data points that have become common knowledge in these digital communities. He looks at statistics showing that approximately 70 to 80% of divorces are initiated by women, and he examines the correlation between higher education levels in women and higher initiation rates. In 2026, the help Ethan seeks is often found in AI-driven legal risk analysis tools. These programs can ingest the specific laws of a state, the historical rulings of local judges, and the financial profile of a potential partner to provide a statistical probability of various outcomes should the marriage fail. This is not about cynicism. For the 2026 man, this is about the same due diligence one would apply to a business partnership. The digital resistance also popularized the concept of hypergamy, the evolutionary biology theory that individuals seek partners of higher status or resource capacity. While controversial, this concept provided a foundational logic for men who felt blindsided by a spouse's departure during a period of financial or personal hardship. The help here was psychological. It offered a way to depersonalize the rejection. Instead of viewing a divorce as a personal failure of character, the red pill framework allowed men to see it as a predictable outcome of shifting socioeconomic variables. This led to a historical trend of outcome independence. In the courtroom of 2026, a man who has internalized this philosophy is less likely to be manipulated by emotional appeals or high-conflict tactics. He operates with a level of stoicism that was rare in the 1980s. Another massive pillar of this digital help was the rise of MGTOW, or men going their own way. This wasn't just a lifestyle choice. It was a form of economic protest that became known in the early 2020s as the marriage strike. Case studies from 2023 to 2026 show a significant decline in marriage rates among high-earning men in the United States. These men realized that the legal help available was often a band-aid on a systemic wound. The best way to win the game, they argued, was not to play. This cultural shift forced the legal industry to adapt. Law firms that previously focused on traditional divorce began offering premarital asset protection packages that were far more robust than the standard prenuptial agreement. Step by step, the digital resistance taught men how to navigate the specific mechanics of the legal system using what they called the gray rock method. Imagine if a man is facing a high-conflict spouse who uses every text message and email as a weapon in the custody battle. The gray rock method, a psychological strategy popularized online, teaches the man to become as uninteresting and non-responsive as a gray rock. Short, factual, emotionless communication. By 2026, this has become a standard recommendation even among mainstream therapists and lawyers. It is a tactical form of help that prevents the man from providing the very evidence that could be used against him in a psychological evaluation. We also see the influence of these movements in the way men handle financial disclosure. In the past, a man might have tried to hide assets, a risky move that often leads to severe legal penalties. The modern digital help emphasizes radical transparency coupled with strategic placement. Men are taught to use historical data to show exactly which assets were premarital, and to maintain strict accounts to prevent the commingling of funds. The help is no longer about deception. It is about the meticulous maintenance of boundaries. The impact of the manosphere and the red pill movement on the American man in 2026 cannot be overstated. It has created a generation of men who are legally literate in a way their grandfathers never were. They understand the difference between equitable distribution and community property states. They know the significance of the 1979 versus or ruling we discussed earlier, and they understand how to use that precedent to argue for gender-neutral alimony. The digital age has democratized the help that used to be reserved for those who could afford $1,000 an hour consultants. However, this cultural shift has also created a new kind of tension in the courtroom. Judges in 2026 are increasingly aware of these digital movements. A man who appears too stoic or too well-prepared can sometimes be viewed with suspicion, as if he is following a script from an online forum. This is where the help has had to evolve again. The 2026 masterclass for men involves balancing the tactical knowledge gained from the digital resistance with an authentic, empathetic presentation of their role as a father. It is about proving that while they understand the mechanics of the system, their primary motivation is the well-being of their children. As the marriage contract continues to be reevaluated, we are seeing the emergence of the collaborative divorce and private mediation as the preferred tools for the informed man. By bypassing the adversarial courtroom, these men are using the data and strategies they've learned to reach settlements that are more equitable and less destructive. They are moving away from the state-mandated winner-take-all model and toward a customized, contract-based family structure. But even with all this digital knowledge and tactical preparation, there is one area where the system still possesses a terrifying level of power, an area where a single word can override years of data and decades of responsible fatherhood. It is the most potent weapon in the domestic legal arsenal, a tactic that has remained virtually unchanged even as the rest of the system modernized. In the next part, we are going to expose the history of the silver bullet. We will look at how the legal system handles allegations of domestic violence and child abuse, the historical trend of their strategic use during custody filings, and the terrifyingly narrow path a man must walk when his character is assassinated in the public record. If you think the truth is a sufficient defense, you haven't seen the data on how these allegations function in a 2026 courtroom. To understand the phenomenon of the silver bullet, we must look at the legal landscape of the early 1990s, specifically the passage of the Violence Against Women Act of 1994. While this legislation was a landmark achievement in protecting genuine victims of domestic abuse and providing much-needed resources for safety, it inadvertently created a mechanism that could be utilized as a tactical weapon in the high-stakes environment of family court. This mechanism is the ex parte order of protection. In legal terms, ex parte means from one party, which allows a judge to issue a temporary restraining order based solely on the testimony or affidavit of one person, without the other party being present or even aware that a legal action is taking place. Historical trends show that in the decades following 1994, the frequency of these orders skyrocketed during the initial stages of divorce filings. Imagine a man named Christopher in the year 2026. Christopher is a project manager with no criminal record and a clean history. On a Tuesday afternoon, he is served with an emergency order that requires him to vacate his home immediately, surrenders his firearms, and ceases all contact with his children. He has not been charged with a crime, and he has not had the opportunity to speak to a judge. This is the reality of the silver bullet. In the eyes of the court, the potential risk of harm outweighs the due process rights of the accused in the short term. For Christopher, the help he needs is no longer about asset division. It is about basic civil liberties and maintaining a thread of a relationship with his children. The impact of the silver bullet is immediate and devastating. Because the best interests of the child standard prioritizes safety above all else, an allegation, even one that has not yet been proven, frequently results in an immediate suspension of parenting time or a transition to supervised visitation. In 2026, the help available to men in Christopher's position has evolved into a high-stakes counteroffensive of documentation. Case studies from recent years indicate that the first 72 hours after being served are the most critical. Christopher's legal team will not just look for a defense. They will look for forensic evidence to rebut the specific claims made in the affidavit. Let us look at a step-by-step breakdown of how this functions in a 2026 courtroom. First, the court looks for a preponderance of the evidence, which is a much lower bar than the beyond a reasonable doubt standard used in criminal law. If the petitioner claims that Christopher was aggressive on a specific date, the burden is on Christopher to prove a negative. This is where the help of digital forensics becomes a literal lifesaver. In 2026, men are increasingly utilizing smart home data, GPS pings from their phones, and even wearable tech that monitors heart rate and activity levels to show that they were not even in the vicinity, or that their physiological state remained calm during the alleged incident. The historical trend of the silver bullet has also led to the rise of the supervised visitation industry. If a judge decides to keep a temporary order in place until a full hearing can be held, which in 2026 can take months due to court backlogs, the father is often relegated to a visitation center. Here, he must pay an hourly fee to see his children in a sterile room while a social worker takes notes on his every move. This creates a psychological status quo that is incredibly difficult to break. By the time Christopher gets his day in court to prove the allegations were unfounded, his children may have gone 6 months without seeing him in a natural environment. The court, hesitant to disrupt the children's new routine, may then use that very gap in time as a reason to limit his future custody. This is the structural trap that modern help for men is designed to anticipate. Another critical case study involves the 2024 reform movements in states like Texas and Florida, where legislators began to realize that the lack of consequences for false allegations was undermining the credibility of the entire system. Before these reforms, there was almost zero penalty for a spouse who filed a demonstrably false order of protection to gain leverage in a custody battle. Modern help for men now involves pushing for sanctions and the recovery of legal fees when an allegation is proven to be a strategic fabrication. However, the potential outcomes remain risky. A man who fights too aggressively against an allegation can be labeled as litigious or angry, further feeding into the narrative used against him. Imagine if Christopher's spouse utilized the latest in 2026 technology, AI voice cloning or deepfake video. We are seeing a historical shift where traditional evidence is being questioned at a fundamental level. Help for Men now includes digital authentication experts who can analyze metadata to prove that a supposedly incriminating video or audio clip was synthesized. This is a far cry from the 1950s where a man's word was often enough. In the modern era, the American man is fighting a battle against both legal precedent and technological manipulation. We must also examine the career-ending potential of these allegations. For men in professions that require security clearances, medical licenses, or teaching certifications, a temporary order of protection can trigger an immediate suspension of their livelihood. The historical trend shows that the silver bullet is often timed specifically to coincide with a man's peak professional pressure, forcing him to settle for less custody or a lopsided financial agreement just to get the allegations dropped and save his career. This is the definition of legal extortion, and the help available today is focused on emergency stays and specialized employment law interventions that sit alongside the family law case. Despite the grim nature of these tactics, the data suggests that the tide is slowly turning. As more women enter high-earning roles and the 50-50 custody movement gains ground, the strategic use of these allegations is beginning to face more judicial scrutiny. Judges in 2026 are becoming more attuned to the patterns of high-conflict filings. They are looking for the smoking gun of timing. Did the allegation of abuse only surface exactly 3 days after the divorce was served? Was there a history of police reports? Or is this a sudden revelation intended to secure the house? The history of the silver bullet is a history of the system's struggle to balance the absolute necessity of protecting victims with the constitutional requirement of due process. For the American man, navigating this requires more than just a lawyer. It requires a fortress of documentation and a level of emotional discipline that can withstand the most extreme provocations. You have to be perfect when the system is looking for a reason to prove you are flawed. But even if you survive the allegations, even if you keep your house and your career, there is a final, invisible frontier that every divorced man in America eventually faces. It is a hurdle that doesn't exist in the courtroom and isn't written in any law book. It is the social and communal fallout that occurs once the legal dust has settled. It is the moment when the man realizes that while he won the legal battle, he may have lost the cultural war in his own neighborhood. In the next part, we are going to dive into the history of the social exile. We will look at how the American community shifted from supporting the family unit to picking sides, the historical trend of the discarded father in social circles, and the specific help available for rebuilding a life from the ground up when your old social network has vanished. If you think the judge is the only one who can judge you, you haven't seen the power of the Suburban Whisper campaign. The Suburban Whisper campaign is the unofficial, unrecorded courtroom of public opinion, and for many men, its verdict is far more permanent than any ruling handed down by a judge. To understand the history of social exile, we have to look back at the 19th century American village. In that era, the church and the local community were the primary arbiters of social standing. If a marriage failed, the social help available was almost entirely dependent on which party was perceived to have maintained the moral high ground. Historically, if a man was seen as the provider who was abandoned, the community might rally around him. However, as we transitioned into the mid-20th century, a new historical trend emerged: the couple friendship dynamic. In the 1950s and 60s, social life became centered on the nuclear family unit, meaning that when the unit broke, the social infrastructure supporting it often collapsed for the man. Imagine a man named Brandon in the year 2026. Brandon is a 42-year-old software executive who has lived in the same cul-de-sac for 12 years. He coached the Little League team, attended the neighborhood block parties, and shared a group chat with 4 other fathers on the street. The moment his divorce was filed, an invisible barrier began to rise. This is the social friendship audit. Statistics and historical trends from the last decade suggest that men lose approximately 30 to 40% of their social network during a divorce, compared to a significantly lower percentage for women. This happens because, in the modern American social structure, the wife often acts as the social secretary for the family. She is the one who maintains the calendars, organizes the dinners, and communicates with the other mothers. When the separation occurs, the other couples in the neighborhood often default to the person they communicate with most frequently. For Brandon, the whisper campaign began with the omitted invitation. Imagine if Brandon sees the photos of the annual neighborhood summer barbecue on social media, a party he attended for a decade, and realizes he was the only one not invited. When he asks a neighbor about it, the response is a polite but cold explanation that they didn't want to make things awkward. This is the help Brandon actually needs but rarely finds in a law office: a strategy for social survival. In 2026, the help for men has evolved into the cultivation of a third space. Historically, the first space was the home and the second was the workplace. The third space, the pub, the social club, the fraternal organization, is where men historically found their tribe. As these spaces vanished in the late 20th century, men became more socially isolated within their marriages, making the divorce-induced social exile even more lethal. Let's look at a case study of the modern social reconstruction process. In 2026, Brandon doesn't try to win back his old neighbors. He understands the potential outcomes of that battle are usually futile. Instead, he follows a step-by-step detail of what sociologists call high-value networking. He begins by joining a local Brazilian jiu-jitsu gym or a high-end car club, environments that are traditionally male-dominated and merit-based. Historical trends show that men who engage in physically demanding or skill-based communities post-divorce report a 50% higher rate of psychological resilience. These spaces provide a new social script where his marital status is irrelevant to his standing in the group. This is the modern version of the 19th century men's lodge, updated for the digital age. The suburban whisper campaign also utilizes the weaponization of the school gate. Imagine Brandon showing up to his daughter's soccer game and noticing that the other parents, people he once considered friends, are physically moving away from him or lowering their voices as he approaches. This is often fueled by the silver bullet allegations we discussed in the previous part. Even if the allegations were dismissed in court, the social stain remains. In 2026, the help for this situation involves a tactic known as radical transparency with a limited circle. Brandon identifies 2 or 3 key influencers in his social sphere and provides them with the factual, documented truth of his situation, without disparaging his ex-spouse. He allows the truth to filter back through the grapevine, countering the whisper campaign with a quiet, dignified consistency. We also have to examine the data on the friendship divorce. Research suggests that mutual friends often feel a sense of survivor's guilt or fear that divorce is contagious. By distancing themselves from Brandon, they are subconsciously protecting their own marriages from the reality of failure. The help Brandon finds in 2026 includes professional social coaches who specialize in post-divorce reentry. These experts teach men how to rebuild their social capital from scratch, focusing on the quality of new connections rather than the quantity of old ones. They emphasize the historical trend of the Renaissance man, someone who uses the freedom of his new life to pursue interests he suppressed during the marriage, thereby attracting a new, more aligned social circle. Step by step, Brandon begins to replace the group chats he was kicked out of with new networks of men who have navigated similar paths. In 2026, we see the rise of the fraternity of the disenfranchised. These are not just support groups. They are masterminds for life after divorce. They offer tactical help on everything from solo travel to the nuances of modern dating as a father. This is a far cry from the 1970s, where a divorced man was often seen as a tragic figure living in a bachelor pad with a folding chair. The 2026 model is about the intentional design of a life that is so socially and personally fulfilling that the suburban whisper campaign loses its power. However, the psychological cost of this social exile is immense. Data from the American Journal of Public Health has historically shown a significant correlation between divorce, social isolation, and a decline in male health outcomes. For Brandon, the help he needs is also biological. He has to combat the spike in cortisol and the drop in testosterone that often accompanies the chronic stress of social rejection. This is why the modern masterclass for men includes a heavy emphasis on physical optimization, nutrition, sleep, and hormone health as a foundation for social rebuilding. A man who is physically thriving is less likely to be perceived as a victim, which in turn changes the social narrative around him. The history of divorce help for men in America is a history of moving from external validation to internal strength. Brandon's journey in 2026 shows that while the neighborhood might turn its back, the world at large is wider than a cul-de-sac. The social exile is not a dead end. It is a forced relocation to a more authentic community. But as Brandon settles into his new life, as he builds his new tribe and stabilizes his finances, a final question begins to emerge. It's a question that every man eventually asks as he looks at the wreckage of his old life and the promise of his new one. It's the question of the legacy. After the lawyers are paid, the house is sold, and the friends are gone, what is left of the man? In the next part, we are going to look at the history of the father's legacy in the wake of divorce. We will explore the historical trend of the long-distance father, the rise of the intentional patriarch, and the specific strategies used in 2026 to ensure that a divorce doesn't just change your family structure, but actually strengthens your bond with the next generation. If you think the story ends with a settlement agreement, you haven't seen the power of the reclaimed fatherhood. The reclaimed fatherhood is not an accident of the legal system. It is a deliberate architectural choice made by the modern man who refuses to be relegated to the margins of his own family tree. To understand the gravity of this shift, we must look at the historical trend of the Sunday father. In the 1970s, 80s, and even well into the 90s, the American legal system operated on a standard of visitation. The very word visitation suggests a temporary, guest-like status, akin to visiting a relative in a hospital or an inmate in a prison. For decades, the potential outcomes for a divorced father were socially and legally capped at every other weekend and 4 weeks in the summer. This created a generation of children who viewed their fathers as recreational figureheads, men who provided the fun and the movies but were absent for the homework, the fevers, and the quiet discipline of daily life. Imagine a man named Tyler in the year 2026. Tyler is a 38-year-old middle manager who is navigating the aftermath of a high-conflict divorce. In 1985, Tyler's father would have been the Sunday father, a man who lived in a sparse apartment and felt like a stranger in his own children's lives. But in 2026, Tyler has access to a completely different historical framework. This is the era of the intentional patriarch. Tyler understands that his legacy is not defined by the title of husband, but by the consistency of his presence as a father. To achieve this, he utilizes a strategy that has gained massive traction in the last 5 years: parallel parenting. Step by step, parallel parenting allows Tyler to remain a primary influence without engaging in the toxic cycle of high-conflict co-parenting. Historical trends show that the traditional model of co-parenting, which requires constant communication and collaboration between ex-spouses, often fails in high-conflict scenarios, leading to the eventual withdrawal of the father to keep the peace. Parallel parenting is the 2026 solution. It involves a total decoupling of the two households. Tyler has his own set of rules, his own traditions, and his own relationship with the school and doctors. He does not ask for permission to be a parent. He simply executes his parenting time with total autonomy. In his house, the children have their own chores, their own routines, and their own sense of stability that is entirely independent of what happens at their mother's house. This shift is backed by a mountain of data that has emerged since the early 2000s. Case studies from organizations like the National Fatherhood Initiative have shown that children with highly involved fathers, regardless of the marital status of the parents, are 43% more likely to earn A's in school and 33% less likely to repeat a grade. They are also significantly less likely to experience poverty or engage in criminal activity. For Tyler, the help he seeks is not just about getting more hours on a calendar, it is about the quality of those hours. He understands that in the 2026 landscape, the state is increasingly moving toward a 50-50 custody default because the social cost of fatherless homes has become too high for the government to ignore. Imagine if Tyler decided to lean into the old Sunday father trope. He would be following a historical path toward obsolescence. Instead, he focuses on what sociologists call the ritualization of time. He creates small, unbreakable traditions that anchor his children to him. Every Tuesday night during his week is Taco Tuesday and a board game. Every Saturday morning is a hike or a trip to the local makerspace. These are not just activities. They are the building blocks of a new family culture. By 2026, the help for men has shifted toward this kind of lifestyle engineering. Men are being coached to see themselves as the CEOs of their own household, responsible for the moral and emotional development of their subordinates, their children. We also have to look at the history of the long-distance father. In the 1990s, if a father had to move for work, his relationship with his children was effectively over, relegated to expensive long-distance phone calls and infrequent flights. In 2026, the technological help available has transformed the potential outcomes for these men. Tyler utilizes high-fidelity virtual reality and shared digital workspaces to remain present, even when he is physically distant. He doesn't just call his kids. He plays immersive games with them in a shared VR environment, where they can see his movements and hear his voice in 3D space. He helps them with their homework using augmented reality overlays. This is the digital bridge that prevents the historical trend of the disappearing dad. However, the most critical part of the reclaimed fatherhood is the concept of the micro-legacy. Historically, men thought of legacy in terms of inheritance, the house, the stocks, the family business. But in the volatility of the 2026 economy, Tyler realizes that his true legacy is the psychological resilience he models for his children. He shows them how to handle a crisis with dignity. He shows them that a man can be broken and yet rebuild himself. He teaches them the history of their family, ensuring they know they belong to a lineage that is bigger than the current divorce. Step by step, he is documenting this for them, creating a digital time capsule that includes his own thoughts, his mistakes, and his hopes for their future. The data also points to the importance of the father's gatekeeping role. Historical trends in family psychology have often focused on the mother as the gatekeeper, but in 2026 we recognize the father as the one who introduces the child to the world. Fathers typically encourage more risk-taking, more independence, and more exploration. By reclaiming his 50-50 role, Tyler is ensuring that his children receive this essential developmental input. He is not just a provider of child support, he is a provider of character. The legal help he utilized to secure this time was an investment in the long-term mental health of the next generation. As we examine this historical transition from the visitor to the patriarch, we see that the American man has had to fight for every inch of this ground. It required the alimony reforms of the 2010s, the joint custody laws of the early 2020s, and the cultural shift of the mid-2020s that began to celebrate the hands-on father. Tyler is the beneficiary of a war he didn't even know was being fought while he was growing up. But as he looks at his children sleeping in their own beds in his own home, he knows that the battle was worth it. He has moved from a man who was losing everything to a man who is building something permanent. But even with the kids, the money, and the house secured, there is one final piece of the puzzle. It is the part that most men ignore until it is too late. It is the internal transformation that must occur to ensure that the man who emerges from the divorce is actually better than the man who entered it. You can win every legal battle and still lose yourself in the process. In the final part of this masterclass, we are going to look at the history of the reborn man. We will explore the historical trend of post-divorce peak performance, the rise of the 2.0 lifestyle, and the specific step-by-step details on how to use the trauma of the last year as the fuel for the greatest decade of your life. If you think this video was just about surviving a legal process, you are about to see the blueprint for thriving in a world that expected you to fail. The final chapter isn't about the divorce at all. It's about the man you were always meant to become. The concept of the reborn man is not a modern invention, but it has undergone a radical transformation in the American consciousness over the last century. Historically, a divorced man in the early 20th century was often seen as a social pariah, a man who had failed in his primary duty as the pillar of the community. He was expected to fade into the background, perhaps living in a modest boarding house. His life effectively stalled. However, a significant historical trend began to emerge in the late 1970s and 1980s, coinciding with the rise of the self-help movement and the fitness revolution. The image of the broken man began to be replaced by the potential outcomes of post-traumatic growth. By the year 2026, this has evolved into a sophisticated, data-driven blueprint for personal optimization that we call the 2.0 lifestyle. Imagine a man named Marcus in the year 2026. Marcus is 45 years old and 18 months ago. His life was a heap of legal documents, bank statements, and moving boxes. He had lost his primary residence, 40% of his retirement savings, and the daily presence of his 3 children. In the 1950s, Marcus might have turned to a bottle of scotch and a slow decline. But Marcus is a student of the historical trends we have discussed in this masterclass. He understands that the dissolution of his old life is not a death sentence, but a demolition project that has cleared the ground for a more resilient structure. The help Marcus seeks now is not found in a courtroom, but in the radical recalibration of his physical, financial, and psychological self. Step by step, Marcus begins with a physical reconstruction. Historical data from the early 2000s showed a terrifying correlation between divorce and male health decline, including increased rates of cardiovascular disease and depression. In 2026, the help available for men includes integrated wellness protocols that treat physical fitness as a prerequisite for legal and emotional stamina. Marcus doesn't just go to the gym. He engages in a high-intensity functional training program designed to spike his natural testosterone and lower his cortisol levels, which have been chronically elevated by 2 years of litigation. He utilizes wearable technology to track his metabolic health and sleep hygiene. This is the first pillar of the reborn man. The realization that you cannot lead a family or a career if you are physically falling apart. Case studies of men in 2025 who prioritize physical optimization during divorce show a 60% higher rate of successful mediation outcomes, simply because they possess the mental clarity and emotional regulation that comes with physical health. The second pillar is the financial recalibration. We have looked at the history of wealth transfer, but the reborn man focuses on the history of wealth creation. Marcus looks at his reduced bank balance not as a loss, but as a lean starting point. Historical trends show that many of the most successful male-led enterprises in the United States were founded in the 5 years following a major life upheaval. The pressure of alimony and child support, while heavy, often acts as a powerful catalyst for professional innovation. Marcus moves away from the 1990s model of being a loyal corporate soldier and toward the 2026 model of the fractional executive or the specialized consultant. He leverages the digital tools and global networks we discussed in the part about the digital resistance to create multiple streams of income. He treats his finances with the same clinical precision he used to fight his custody battle, focusing on asset protection and high-yield investments that the state cannot easily reach in the future. Now imagine if Marcus tried to jump immediately into a new relationship to fill the void. This was the historical trend of the 20th century, the rebound marriage that often ended in a second, even more disastrous divorce. The 2026 masterclass teaches a different path. The period of intentional solitude. Marcus spends a full year focusing on his own development before even considering a serious partnership. He uses this time to audit his own psychological history. He looks at the patterns that led to his first marriage and the red flags he ignored. This is the help provided by the new wave of male-centric therapy that focuses on accountability rather than victimhood. He learns the history of his own emotional triggers and develops a level of stoicism that makes him nearly immune to the high-conflict tactics that once kept him awake at night. The third pillar is the social and communal rebirth. Marcus has navigated the suburban whisper campaign and the social exile we discussed previously. Instead of trying to crawl back into a community that rejected him, he builds a new one based on shared values and mutual growth. In 2026, we see a historical trend of men's masterminds and brotherhoods that go far beyond the superficial friendships of the past. Marcus joins a group of 10 men who meet weekly to discuss their goals, their parenting, and their legacy. These groups provide a form of social help that is both defensive and offensive. They offer a sounding board for his decisions and a support network that is not dependent on his marital status. This is the reclamation of the third space, updated for a generation that values transparency and results over social standing. The potential outcomes for Marcus in 2026 are vastly different from the men of 1976. He is leaner, wealthier, and more emotionally stable than he was during his marriage. He has a deeper, more intentional relationship with his children because he no longer takes their presence for granted. He has moved from being a passenger in his own life to being the architect of it. This is the hidden history of the American divorce. It is the greatest filter in a man's life. It filters out the weak habits, the false friends, and the outdated beliefs. What remains is the core of the man, and if that core is tempered correctly, it becomes unbreakable. Step by step, Marcus has followed the blueprint. He documented his legal battle, protected his fatherhood, ignored the whispers, and optimized his body and mind. He is now the version 2.0 of himself. When he eventually decides to enter a new relationship, he does so from a position of total strength, with a postnuptial or prenuptial agreement that reflects his new understanding of the legal landscape. He is no longer a victim of the system. He is a master of it. The cultural history of divorce help for men in America is a journey from the patriarch who owned everything to the man who was stripped of everything, and finally to the reborn man who builds everything for himself. It is a story of resilience, adaptation, and the enduring power of the male spirit in the face of systemic change. You have watched this 10-part deep dive because you are looking for that same path. You have seen the history of the laws, the money, the kids, and the social fallout. Now you see the destination. But there is one final reality that we must address. All the history, the data, and the case studies in the world cannot save a man who is not willing to save himself. The system is designed to process you, the lawyers are designed to bill you, and the culture is often designed to forget you. The only person who is truly invested in your rebirth is you. As you step out of this masterclass and back into the reality of your own journey, remember that you are walking a path that millions of men have walked before you, but you are walking it with the tools and the knowledge of 2026. The blueprint is in your hands. The history is on your side. The only thing left is the execution. As we close this series, understand that the true help for men in America isn't a law or a lawyer. It's the realization that your greatest chapter is usually written on the pages that follow your most difficult ending. We have explored the past and analyzed the present, but the most important history is the one you are about to write starting tomorrow morning. The era of the defeated man is over. The era of the reborn man has begun.